Good morning, good afternoon, good evening. I hope you're all doing well this fine Wednesday. It's 1 p.m. here in the UK. It's still pretty cold. It's not that bad, actually. It's the wind. The wind is really cold. When there's no wind, it's fine, but the wind is really cold. Anyway, we're here to talk about the Karen Read case today. So I've been following the Karen Read case through all the pre-trial motions, the pre-trial hearings last year. And we are here again. But I don't talk about Karen Read much. I've done a handful, a little spattering of live streams and videos on Karen Read, but I don't talk about it routinely. I don't talk about it every time there's a new motion filed like I do with Delphi or, you know, a new hearing. I just don't. It's a case that I think is incredibly polarizing, and we've seen that over the last 20 hours. We've seen just how polarizing this case is. And I have an opinion on it. I personally believe that Karen Read is factually innocent of the charges that the Commonwealth of Massachusetts have brought against her. However, I don't think I'm so heavily polarized that I'd be prepared to stake my life on it. Except there's no way, this is my opinion, there's no way that the injuries to John O'Keefe happened via a motor vehicle collision. There's no way. And the marks on John O'Keefe's right arm are 100% from a dog bite. For those reasons, it's John O'Keefe's injuries. For those reasons, I believe that Karen Read is factually innocent. If somebody can come along and give me evidence as to how his injuries could have occurred in the way that the Commonwealth says they happened, then I'll happily change my mind. Happily. However, we're here to talk about something very specific today. Kimberly, thank you for gifting 5 memberships. That's very, very kind of you. We've got Amy, Kate, Storm Life, Gotcha, and Labrant. So thank you so much, Kimberly, for the 5 memberships, and welcome, you guys. If you've never been a member before on this channel, go and check out the members area. We've got members lives, we've got little videos, we've got bloopers, we've got statuses, pictures, all sorts of stuff on there. So go and check it out. All right, we're here to talk about something very specific that happened at yesterday's pre-trial motions hearing. And it has set the Karen Read community alight with shock and horror on one side, and then on the other side, gloating and I told you the defense were dirty on the others. So I've tried to go away and make some sense of what happened. So for those not familiar with the case, before we get into it, just let me say this. Karen Read is accused of second-degree murder of her then boyfriend, Boston cop John O'Keefe. And the Commonwealth of Massachusetts are claiming that she murdered John by running him over outside a house called 34 Fairview Road in Canton, Massachusetts, not far from Boston. And they'd been out drinking, so there was a lot of alcohol involved, and Karen was over the limit. She drove from the bars that they were partying in to the house of another Boston cop called Brian Albert, and she dropped John off. So it was like an after party. She didn't want to go in. and she dropped John off. She claims that she saw him either going towards the house or going in the house. She claims that she saw him enter 34 Fairview. However, he didn't come home. So it turns out that John didn't go home because he was lying dead on the lawn of 34 Fairview. And he had a head injury and some marks on his right arm. So that's pretty much it, right? The head injury was a bleed, and that's likely what killed him. According to the autopsy, it was the head injury that killed him. However, there was also hypothermia involved because it was snowy. It was in January. I think it was January 29th. I think the early hours of January 29th, 2022. And it was a very, very cold night, and it snowed that night. So it was pretty much a blizzard by the morning. By the time John was found, it was snow-covered blizzard conditions. All right. So he had hypothermia. So we've been out there a while. To get a hypothermia, we've been out there a while. So the Commonwealth are claiming that she did this intentionally, that she was mad with him, and they had been arguing. There were some problems in their relationship, that she'd got mad and she'd backed into him and done it on purpose, and therefore it's murder. The defense, however, claims something very different. They claim that John was murdered by the occupants of the house of 34 Fairview. The Albert family and the McCabe family are in it together, and they've covered all of this up. So the defense in the first trial, so yeah, there was a trial. That was their defense. Third party culprits. They really hammered the McAlberts. Right, the cross examinations were fantastic. They were really good. It was a really good trial. So the trial of Karen Reid for this murder charge started the end of April last year, and it went all the way through May and all the way through June. And then the jury, I think they deliberated for something like 25 hours. And it turns out that there was deep divisions amongst the jury, and they returned a verdict of, we are hung. We are hung. So it was a hung jury. Now, she's due to go to retrial. The Commonwealth are still charging her with second-degree murder, and then there's lesser charges that the jury could choose instead, like manslaughter. And it's due to go to trial, I think, the beginning of April. The trial is set for, I think, 1st of April, I want to say, for the retrial. So yesterday was the motions hearing, and at the end of that motions hearing, well, it wasn't meant to be the end of that motions hearing, but the judge seemed absolutely furious she was. So we're going to get into that, and I'm trying to put together a timeline of how this potential fraud or whatever the Commonwealth trying to say that it is, how this has all arisen. And it's either going to be a massive big deal that results in maybe one member of the defense team losing his license to practice in Massachusetts, that of Alan Jackson. Alan Jackson is a very well-respected attorney. He practices out of California, but he's got a special license to practice in Massachusetts just for this trial, right? And potentially he could lose his license to practice in Massachusetts and he'd be off the team. Or it could be an absolute storm in a teacup, because the way it looks to me is that Hank Brennan, the special prosecutor, has got his facts wrong. Maybe a little bit twisted, like a faux pas, maybe. He admitted to a faux pas. I don't know whether he did it on purpose or not. If he didn't do it on purpose, then he's probably pretty embarrassed. But we're going to get into it. And we're going to show, first of all, what we're talking about here. And we're going to bring in some pieces of evidence from last year's trial to try to piece this all together. Because when this all went down, I told you, I was live yesterday afternoon and I said, I'm going to go and watch the Karen Reid hearing. And I was doing something else at the same time. So I had one ear on the hearing and then I was a little bit divided in my attention, and I'm not very good at multitasking. But anyway, there was this recess, and I thought, she's taking her time. Why is she recessed? We're only an hour and a half into this, because there was a whole bunch of motions that were going to be heard at this hearing. And it took like half an hour. She came back, and then she was like, I've got grave concerns, blah, blah, blah. So I had to rewind. I rewound half an hour and went to listen to what Hank Brennan said. So it became very clear to me why the judge was furious. Furious. All right. Hank, I think, got it wrong. So do I. But this is why I'm not going to come out and say out and out loud. I know a lot of the pro Karen Reid, the free Karen Reid people are saying he's a liar. He's done this on purpose. He's ambushed the defense. And it could be that. It could easily be that. I don't trust Hank Brennan, I have to say. Now, Hank Brennan's new to this story because the prosecutor who tried Karen last year in the first trial, Adam Lally, he's now just a bench warmer. He's been resigned to the subs bench, and they've brought in a special prosecutor, Hank Brennan, and Hank Brennan has already rubbed me up the wrong way. We've not even got to trial yet, and he's rubbed me up the wrong way. He's basically doing his job, right? He's trying to make his job easier by getting a load of stuff like the experts that the Karen Reid defense team brought out the first trial. He's trying to get them all removed so that they can't testify in April at the next trial. So he's tried with the dog bite expert. He's tried with the defense's phone expert. And now he's trying to get the crash test people removed. So there's a little bit more backstory that you need to know. There's a federal investigation going on. So alongside the trial of Karen Reid as of last year, at the same time, there was a federal investigation going on that led the feds into investigating the Karen Reid case. And the feds had got their own crash test experts, this organization called ARCA. They were contracted on behalf of the feds to investigate the car, Karen Reid's car, and the death of John O'Keefe. And their experts concluded, pretty much like I have, that the death of John O'Keefe, in their expert opinion, and remember, these are guys, experts, doctors in their field, contracted by the feds to do this investigation. It's completely separate from the Karen Read trial, the Karen Read investigation. Like I said, the federal investigation started off elsewhere, and their findings have led them into the Karen Read case. But they, at the time of the last trial, they were completely independent. However, what they did do was send their report to both the Commonwealth and the defence. This was last year, before the first trial. The Commonwealth ignored the report, but the defence listened. The defence took it up because the report from these ARCA experts was that the death of John O'Keefe, in their expert opinion, was not caused by a motor vehicle collision, right? Well, obviously the Commonwealth don't want that, because the Commonwealth's case against Karen Read is that Karen hit John with her car, and that's what killed him. But the ARCA guys said no. In their expert opinion, they don't believe that John O'Keefe's death, his injuries, were caused by a motor vehicle collision. So the defence brought them as expert witnesses into the last trial, and they were brilliant. They were really good. So Hank Brennan, who's this guy on your screen right now, Hank Brennan wants their testimony out, but he's not out and out said that, because he thinks he's got a gotcha moment. He thinks he's caught the defence on the hop. He thinks he's caught the defence basically duping the court, frauding the court. I don't know what word to use, really. He used the words duped. All right, so we're going to listen to Hank Brennan introducing this motion. And as we go through, we're going to play a bunch of clips from last year. And I've not said any hellos once again, but hello, everybody. I hope you're all well. Oh, just let me pick that up. That's about Sebastian's case. K9 Captain Jules is doing a live remax about Sebastian Rogers' case, in case anyone is interested. 6 p.m. Thursday Central. I wouldn't hold your breath. The reason why is that she's had that live planned for weeks now, and she just keeps moving the time. So I wouldn't hold your breath. But anyway, all right, this is Hank Brennan from yesterday. All right, so he gives this short speech, and then Judge Beverly Canoni calls an half-an-hour recess. She comes back, and she's big mad. She's furious. She's fuming. She's like her voice, it's like she's breathless. She's breathless. All right, so what I'm going to do is I'm going to play it through, because it's only dead short. I'm going to play it through, and then I'll rewind, play it again, and we'll go through it bit by bit. Let's do that. Yeah, she was shaking. She was shaking. She was really discombobulated. All right, so I'm going to play this through, only a couple of minutes, and then we'll fast forward half an hour. Watch the judge come back all like confused and big mad. And then we'll break it all down. Hold on. I do have it sped up to 1.25. So I'm going to keep it on that. But if it's too fast, I don't think it's too fast. But if it's too fast, I'll just put it on normal speed. It just saves a bit of time, that's all. All right, so this is Special Prosecutor Hank Brennan.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about, they can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with the retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. It relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attach my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes, I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question, my fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
All right. So Hank Brennan thinks he's got a gotcha moment there. All right. Let's listen to him walk it back, shall we? Or at least walk a little bit of it back. Let's wait. So we got the ceiling fan. For those of you who've been missing the ceiling fan is back. All right. So Judge Bev comes back. Oh, we got to keep going. All right. Right the way here. Okay. She comes back and she is mad. Well, what was that about a mistrial? Will this result in a mistrial? No, because there's no trial. The first trial happened last year, resulted in a hung jury. The retrial, we've not got to it yet. This is a pre-trial motions hearing. So there's no issue about a mistrial because there isn't a trial ongoing. However, Judge Bev is big mad and she does have options. All right, so let's listen to what Judge Bev says when she comes back.
Okay, session may be seated. Make sure your cell phones off, put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
So defense and defense counsel. So Karen Reid's defense, but also the counsel. So the attorneys. Profound effects, grave concern.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of.
Oh, a brief chronology. All right, let's listen to Hank Brennan walking back part of his gotcha moment. Don't worry, we're going to break it all down. If you're confused right now, because I was confused. The first time I heard that, I was really confused. But I had to go back and I had to kind of work through all the different bits. So there's part of this where he either misled the court purposefully or he made a massive boo-boo. I don't know which it is. I don't know because I'm not in his head. But let's listen here to his brief chronology. Okay, brief chronology. So she lets Hank Brennan speak. She lets him speak. Bear in mind, she's now called a stop to this hearing. And she wants them to come back next week. So she's left the defense hanging for a week. Right? She's just called a halt to it. Now, I don't know why she's not asked the defense to respond. Maybe she thinks she's being fair-minded by just closing it and then coming back next week when they've had a chance to prepare. But how will they know what they've got to prepare for? So I'm guessing there's going to be a lot of maybe behind-the-scenes communication that goes on in this week, or else the defense are going to come back and not know what they're preparing for, surely. But listen to Hank Brennan's Walkback.
If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6th, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline.
Oh, so the defense sent all of what he read. The defense sent that to him, not the federal government. I think that puts a slightly different spin on it than saying, oh, the defense tried to hide all this and I had to go and, pester the federal government. Surely they've got better things to do. No, all of what he read, supposedly coming from the federal government, had actually been sent to him by the defense team. So they weren't hiding anything. Okay.
We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right. So the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right. So the stuff not from the federal government, give me a copy. No questioning. No questioning like, so Mr. Brennan, before the break, you said that all these emails and this outline, everything came from the federal government. You're now saying this was all from the defense sending you this information. because emails are discoverable. I'm not sure about outlines, like a plan of what you're going to talk about with your witness. I'm not sure that that is discoverable. Surely that's work product. Surely that's the person's own work product. I don't know, because I'm not a lawyer, and I'm certainly not a lawyer in my country, and I'm not a lawyer in Massachusetts. But surely any notes that are compiled regarding a witness testimony by any one person is work product. It's not discoverable. Communications might be. Why did he try to mislead? I don't know. I don't know whether it was purposeful or it was just, I don't know, a faux pas, a mistake. And if so, he needs to be jolly embarrassed. But I think the judge here was so mad, so angry, that she thought that the defense had duped her in the last trial, that she could not see the wood for the trees in that moment. In that moment, she heard all this came from the federal government, and the defense didn't tell me any of this. We didn't know any of this. The defense lied during the first trial, and I'm now really, really mad, and I'm going to do whatever I can against Alan Jackson. Now, her options are she could pull his license because, as I said previously, he's a very well-respected attorney, but he practices out of California. The reason why he's here in Massachusetts is because he's on a special license just for this trial. So she has, even though he's private counsel, like Karen Reid's paying him, she can pull his license, therefore he can't practice in her court. She could sanction him, like she could fine him. But at the end of the day, she's now called a halt to this entire proceeding and getting them all to come back in a week's time. And whether she was well-meaning or not, I can't understand why she didn't just ask a few more questions here. Because he's walked back. He said, I'm going to play it again in a minute. And break it down. He said that all these emails and this plan and this conversation between Alan Jackson and Daniel Wolfe, who's one of the experts, all came from the federal government. And where is the defense's discovery? I've been duped. We've all been duped. Where's the discovery? This is a discovery violation. Rule 14, discovery violation. But no, it actually came from the defense, which puts an entirely different spin on it. Surely it does. That the defense is the person who sent this over to Hank Brennan. So, Are they showing the jury? There's no jury, Sharon. There's no trial at the moment. The first trial resulted in a hung jury last June. And the next trial, the retrial, is due to start in April. So these are pre-trial motions. Pre-trial motions. All right, so we'll go back to Hank Brennan. Where does he start? There. All right. We're going to break it down. We're going to break it down bit by bit. I've got some clips to show you.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense.
Although he did put in a motion to exclude the ARCA witnesses. And he's previously put in motions to exclude the dog bite expert and the phone guy. So that's very disingenuous. You are trying to deprive the defense of their experts. You're trying always to deprive the defense of their experts. So that's a lie.
Defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery before a party can call a witness.
All right. So reciprocal discovery. Now, this goes to what I said before about these ARCA witnesses are only known about, are only relevant because of the federal investigation that was happening in parallel to the state's case against Karen Reid. So last year, the federal government, in doing investigations into a whole bunch of stuff that was going wrong in this area of the world, it led them into the Karen Reid investigation, completely separate to the state's investigation against Karen Reid. All right. And the feds, they contracted ARCA, who is a private company, who are like crash test experts, to do some work for them on Karen Reid's vehicle and the death of John O'Keefe. Okay. So once that report was done, the ARCA experts believed that the injuries caused to John O'Keefe's death overall, in their opinion, was not caused by a motor vehicle collision, which automatically then makes Karen Reid innocent. Okay. Last year, before last trial, ARCA sent their report, which was done on behalf of the federal government. They sent their report to both the Commonwealth and the defense in the Karen Reid case. This was before last trial, last year. Right? The Commonwealth ignored it. The Commonwealth had the opportunity to take on board those results and then, I don't know, change their opinion accordingly. They chose not to. So, therefore, the defense called them as part of their case. The defense called them. And, of course, ARCA, the guys from ARCA, are going to believe Karen Reid is innocent because the result of their independent, and it was independent at the time, it was independent because it was on behalf of the federal government, completely independent of the state's case against Karen Reid. Right? But all their tests they did, they concluded that John O'Keefe's death was not a result of a motor vehicle collision. Therefore, Karen Reid must be innocent. So they came and spoke at Karen Reid's trial last year as defense witnesses. Okay.
It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about.
What information is unavailable to them? We'll get there in a minute.
Is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason.
Well, there was. As a result of their expert experiments, the guys from ARCA concluded that John O'Keefe's death was not caused by a motor vehicle collision. So even though they were independent, they were contracted by the federal government. Again, this federal investigation was separate to the state's investigation against Karen Reid. But once ARCA got their report, they summarised, you know, they got all the results together, and they concluded that John O'Keefe's death was not caused, in their opinion, by a motor vehicle collision. Then, of course, they then, you know, look at the Karen Reid case and think, well, this woman is on trial and she's innocent because we're the experts. We've been contracted by the feds. We've done a bunch of tests, and the results of our tests are that we believe Karen Reid did not kill John O'Keefe. So by the end of their investigation, they were biased. They were. And they were then willing to come and testify on behalf of the defense, on behalf of Karen, at the last trial. So whatever Hank Brennan says, this is a dirty tactic. In my opinion, this is a dirty tactic to get these experts sidelined. That he's not been successful with the dog bite person. He's not been successful with the phone guy person. He's trying a different tactic. In my opinion. That's just my opinion. So where he says there's bias and favoritism, well, there wasn't originally. It wasn't originally because their tests were independent of the state's case against Karen Reid, and they weren't contracted by the defense to do that work. They were contracted by the feds, and they sent their report. So, i.e., you know, that their discovery, I guess you would say, to the Commonwealth last year, they sent it to the defense. The defense took them seriously. The defense contacted them. The defense communicated with them. The defense got them there as part of their case at last year's trial. So nothing wrong here so far. Despite his flowery language, there's nothing wrong here so far.
So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not.
Well, it's not an unfair examination because the Commonwealth got the ARCA report at the same time the defense did.
ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery.
You have the discovery. You have the result of the ARCA experiments. You've had that for over a year. You've had that since before the last trial.
If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations.
All right, so Rule 14, he's now trying to say that there's been a discovery violation, blah, 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 blah.
Basic discovery. Now, I wasn't at the last trial, but I've read the transcripts.
All right, well, you've read the transcripts. That's great. You could have just watched the trial because multiple channels streamed it. So you could have just watched it rather than read the transcript. However, he's got the transcript page for Judge Bev. We're gonna listen. We're gonna listen to it. We're gonna listen to it. We don't need the transcript. We're gonna actually listen to it.
And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a CHORLEY request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
Both sides have reports that both sides have.
Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that. You have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10th, 2024.
All right, June 10th, 2024. Here we are, June 10th. So this was day 22 of the trial. So the jury weren't in that day. This was, or maybe they came in later. I think they came in later. All right. So this was right at the beginning of the day. So this was to sort out some potential witnesses that the defence wanted to call. And this was the discussion that Hank Brennan is referring to here. So June 10th, 2024, day 22 of the trial. And this is David Yannetti. He is the, I think he's like lead defense attorney because he's, he practices in Massachusetts. He's kind of the lead defense because he's the one that has kind of signed for Alan Jackson to practice for this trial only. Anyway, this is David Yannetti for those that don't know him. So they're talking here about potential discovery violations. All right. So it starts, I've started this just a tad early so we get the full context. But this is word for word what Hank Brennan just said, that Bev says in a minute.
Can you imagine the nerve of the Commonwealth to spend that?
This is the hyperbole I don't need. Could you please get to the point? We've got a jury coming in 15 minutes.
I understand, but this is my integrity.
Hold on, let me slow that down just a tad for those. So jury's coming in 15 minutes. Judge Bev is annoyed. You can tell in her voice, Judge Bev is annoyed at having to deal with this thing. She's annoyed. She's rushing him along. All right. So we've got a highly charged situation here. This is what you don't see when you just read the transcript. You don't see the context. You don't see the annoyance in her voice at having to deal with this. She's rushing him along.
Integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with the dog attack. And I ask you, have they no shame? I'm sure it's not lost on this court that this false filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video.
Did you hear her then? She went, because this was partway through trial, the Commonwealth were trying to put the kibosh on the defence calling certain witnesses. And just like Hank Brennan's trying now, they tried to target the dog bite expert. So they tried this last year. It failed last year. They've tried it again this year regarding the dog bite expert. It hasn't worked. So Hank Brennan thinks he's being clever by trying to get these Orca guys booted from the trial by another route.
A false video before this good jury hearing this case. Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video.
Can we please? All right, I'm going.
See, right. That was related to the inverted video. So he's saying, oh, well, you know, you let the Commonwealth ride roughshod over us while you allow and say nothing about a fake video. They played, the Commonwealth played a fake video to the jury, in my opinion, to deliberately mislead the jury. The video of Karen Reid's car in the Sallyport garage was inverted, which gave it a whole different perspective. And it was only when some eagle-eyed person realised that they had to come clean. That was played in front of the jury. That's what David Yanetti's going on about here, and she stops him. So just reading the transcript, you don't get this context. So she rushes him along.
to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Mr.
It's
Yannetti.
not Your Honor, most respectfully, it's not a speech. It's
Okay,
a defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14, and let's do it in two separate parts. So so you've changed. You're not calling Frank Sheridan,
No,
right?
we are calling Frank Sheridan.
All right. So you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time. And the court, I believe, has already suggested that voir dire will be done prior to his testimony.
All right. So it's starting to look like we might need a whole day of voir dire, and I'm trying to avoid that. So is the Commonwealth satisfied that when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
Not on Mr. Van Eden, no.
What does the Commonwealth have on Mr. Van E?
On Mr. Van E, all the Commonwealth has is what's contained, the synopsis on page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are, anything beyond that relatively vague synopsis that does not comply with Rule 14.
Okay.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence.
A bench trial might be an alternative if KR wishes. Why would she want a bench trial? Why on earth would she want a bench trial? Why would she want Judge Canoni to decide her fate? Why?
The Commonwealth has received from the defense is contained within the Commonwealth's motion.
Okay. So the defense needs to provide, I'd suggest you listen. The defense needs
I suggest you listen.
to provide what chronological data Mr. Van E relied upon and exactly what his opinion is.
Sure.
All right. By the close of business tomorrow.
That's fine.
All right. Now, regarding the 3 experts from ARCCA.
All right. So I gave you that context that she was mad. There was a bunch of stuff she was mad about. She was rushing him along. Now we get to ARCA, or as she likes to say, ARCCA. All right. So word for word, what Mr. Brennan read from the transcript. This is in Bev's own words here. This is the very terse conversation between Judge Bev and David Yannetti, June 10th, 2024.
So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses.
So they could not prep with us for trial. Okay. So Hank Brennan had a problem with that wording.
That you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
So coordination of their testimony. Coordination of their testimony. So what you're going to talk about? So they can't prep them. Right? They can't prep them. The federal government say, oh, no, you can't prep these witnesses because at that time they were contracted by the feds, allowing them to testify, I guess you would say. But the defense weren't allowed to prep them. But they were allowed to coordinate with them about their testimony. So the emails that were sent between Alan Jackson and Daniel Wolfe were just that. Like, it was coordination of their testimony, because you've got Daniel Wolfe is going to testify about one thing. You've got another guy who's going to testify about another thing. Of course, the defense had to know what each of these guys were, you know, what part of the report they were going to talk about. So nothing to see here, Mr. Brennan. Sorry. Dear me.
We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
So we've not been able to interview them, but their findings are in the report. They're detailed in the report.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
And you have not complied with your Rule 14
we
obligations.
can't, Your Honor.
So,
We can't.
so you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in voir dire, right?
Yes.
We need to do that well in advance of their
Okay,
testimony.
that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she in?
All right. So they got them in for a voir dire. We're going to play that in a minute. Don't you worry. We're going to play that in a minute. But we'll just, we'll go back to Hank just for another minute here. So him, right, him saying, we don't have their discovery. They've been trying to pull the wool over our eyes. Well, it's a storm in a teacup. It's a storm in a teacup. Because these emails that he now reads out, supposedly secret emails between Alan Jackson and Daniel Wolf, one of the Orca guys, he got them from the federal government. Actually, though, he had to come back half an hour later with his tail between his legs and say, oh, actually, I got them from the defense. Oh, did I say feds? Oh, sorry. I meant the defense. So what is his problem? What is his problem?
Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a 2E letter.
Oh, so you were trying to do the defense a favor. You contacted the federal government to do the defense a favor so that their experts could testify. Wow.
I've been down that road many times. It's a dark road that never sees the light of day. So I filed a 2E.
A 2E letter, by the way, is to get information from the federal government. You got to file a 2E letter.
Comprehensive 2E letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So
the feds didn't respond to their request. However, that's completely irrelevant. The feds didn't respond to their request. Completely irrelevant to the defense here. So you can just disregard that. You know, his annoyance at not being responded to by the feds. Okay, we'll ignore that. We'll ignore that. Then he launches into a bunch of emails that he supposedly got from the feds. Okay. Bear in mind, they've had the Orca report since before the first trial. So they've had the results of these guys' work since well before the first trial.
Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery.
All right. So Attorney McLaughlin got involved, and she was able to get some materials, not much, but some materials, waves them up along. And here is these materials. All right. So he's trying to pass off these materials that they supposedly got from the feds as emails, secret emails between Alan Jackson and the Orca guys. But no, he has to come back with his tail between his legs half an hour later and say, oh, actually, I got them from the defense.
Having not been to the last trial and reading the transcripts, I only have a flavor for the last trial.
Well, isn't it lucky that the last trial was all streamed live, so we can hear about how annoyed Judge Bev was, and we can watch it all as if we were there.
So there is email correspondence between the defense.
So he's made out these materials, this email correspondence comes from the federal government. That's what he's led the court to believe, that these emails that he's going to read now come from the federal government.
Not only the federal government, but the ARCA witnesses themselves. The reason we
So the defense and the ARCA witnesses themselves, which the defense themselves turned over to him. However, Hank Brennan says it was the federal government that he got these from. Okay.
request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf.
All right. So March 2024, so this is a month before the first trial started. There were conversations between Attorney Jackson and Daniel Wolf. Yes, because that's when they got the ARCA report. So Alan Jackson contacted them. I don't understand why that was a problem. The Commonwealth had just as much time to work with ARCA as the defense had, because ARCA, at the time completely independent, contracted by the feds, sent their report to both the Commonwealth and the defense. The Commonwealth ignored it. The defense didn't. So, yes, of course, there were conversations between Karen Reid's defense team and ARCA. Of course there was.
One of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with the retainer as required.
So, along with your retainer as required. Okay. So, the other issue is potentially that the defense paid ARCA for this report. Now, there wouldn't be a problem with them paying a witness. Of course, when a witness testifies, they are paid. You know, like an expert witness. Usually, not always, usually, they are paid. There's a fee. Sometimes it's a fee per hour. Sometimes it's just a, flat fee for a report. Sometimes it's just expenses, travel, hotel, etc. So saying that there's a retainer, basically retaining them for their work. So, give them some money and then they do some work, and then either that's that, they've paid their money, or they say, oh, well, we've still got some work to do. We need some more money. But so this is supposedly, he's saying back in March, but the ARCA guys were contracted and being paid for by the feds. So he's trying to imply here that ARCA were paid by Karen Reid's defense for their testimony at the first trial, which admittedly would be a problem, because they did say, and we'll play it in a minute, they did say to the jury that these guys were not being paid by the defense. So if they did pay them, so they paid by the feds to do independent work, if the defense paid them for their testimony, that's a potential problem. If they paid them for their expenses, that's fine. Because, hotel, travel, that's fine. But paying them for a report that's already been written, paying them for a report that is already paid for by the feds, that's a problem. However, could it be that that's just standard wording that the defense always sends out? It could be standard wording, because generally defense witnesses are paid. But because the defense team weren't allowed, or at least weren't given the opportunity to speak, she just shut this hearing down. We don't know this. We don't know any of this. Now, there was a reporter for CBS Boston who spoke with Alan Jackson after the court, this court hearing. And she asked him, and I don't know whether this was on film. I just heard her talk about it. She asked Alan Jackson, had they paid the ARCA guys for their testimony at the first trial? And he said, no, of course not. So that is up in the air, and it remains to be seen as to what was actually paid for. But it comes up again in a minute.
The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the...
All right, so I assume all of that was the content of the March email. Because it looks like now he's turned the page and he's moving on.
Opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field.
There was an even playing field. In March 2024, there was an even playing field. In March 2024, the Commonwealth were given the same report as the defence were. Just because the results didn't go in their favour, they chose not to engage with ARCA. But they had the opportunity to do so back then. They chose not to. Hank Brennan might not know this because he's new. I'm giving him the benefit of the doubt because he's new. But he needs to do his homework if that's the case.
Saturday, June 22nd.
So Saturday, June 22nd. Saturday, June 22nd. All right. So it's after June 10th, which was this terse conversation between David Yannetti and Judge Bev. June 22nd corresponds with just after the voir dire, which we're going to play a little bit of in a minute. The voir dire, this is Daniel Wolf right here, took place on June 18th. All right, so there's an email now between Alan Jackson and Daniel Wolf. So 4 days after the voir dire. All right, so there's nothing wrong with that. Nothing wrong with that. So up to the point of the voir dire, up to the point of voir dire. Oh, you didn't hear that, did you? Sorry, guys. Go back a minute. All right. I had it on the wrong screen, sorry. All right. I don't know whether you heard that, but I'll go back a bit more. All right, so the returner. All right. All right. All right. So we'll play a bit more. So June 22nd, we're looking for. So June 22nd was after the voir dire. And up to the point when they came for the voir dire, they didn't know that they were going to be witnesses. They didn't know what the court was going to decide. So timeline is important here. Timeline's always important. You know me. You know me. Timeline is always important. So they turn up on June 18th, and we're going to play a little bit of in a minute. They turn up for voir dire on June 18th, after which time Judge Bev then allows them to testify in front of the jury. So June 22nd, 4 days later, Daniel Wolfe and Alan Jackson communicate about the testimony that takes place 2 days later, June 24th. We're going to play a little bit of that as well, because I've got it all. All right. Hank Brennan, you need to get up earlier to get anything past me, son. All right, so let's play a little bit of this that you didn't hear. All right, so, okay. They did have an even playing field. They did have an even playing field. There is sound now, don't worry. There is sound now. What, you still can't hear me? Oh, sorry, guys. StreamYard's done it again. StreamYard has done it again. StreamYard has done it again. All right. Okay, so June 22nd. We are now with June 22nd. Okay, so once again, the first time there was no sound, it was my fault. The second time it was StreamYard, it dropped the audio. Okay. So June 22nd is 4 days after the voir dire, which was June 18th. At this point, as I said, at this point, they're then told that they can testify in front of the jury. When they turn up for voir dire, this is just for Judge Bev's benefit, so that she can decide whether they can testify in front of the jury. That's why they were brought in for voir dire. Okay? So, and then she said yes, they can testify in front of a jury. June 24th, they come in to testify in front of the jury. Okay, got it. All right, we should have sound now. Let me know if there's still no sound. We should have sound now.
It's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd.
All right, Saturday, June 22nd. This is what we're getting to.
Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
All right, so background, qualifications, sends them to Alan Jackson. So, you know, what are your qualifications? What's your experience? All that stuff that they ask witnesses, right? D&T list is how many depositions and trials he's been a witness at before. All right, so boom, got that. And then we've got presumably some kind of outline as to how the testimony is going to go. That's the issue that Hank Brennan's got. He thinks that this has all been secret behind the scenes and he should have known about it. Okay.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, requests. No. This was not information provided by the federal government. This was information provided by the defense. Half an hour later, he walks it back. He's reading from emails between Alan Jackson and Daniel Wolfe.
It's not attorney-client privilege. Attorney-client privilege is between Karen and Alan, not between Daniel Wolf and Alan. So no, that's not relevant. So he's saying that all of this came from the federal government. The defense were hiding all this. No, because half an hour later, he says that these emails came from the defense. Lying. He's lying. Whether he meant to or not, he's lying. He's lying.
And
What a slime ball.
and insistent the best I can to get his.
And Judge Bev, as I said before, Judge Bev either didn't pick up on it because she was so mad, or she chose to ignore it.
Much information as I can. We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being.
Why would you need to know that there was an outline? Why would he need to know that there was an outline for something that was going to happen between an attorney and a witness? That's work product. That is work product. That is not discovery. That is work product. So does Hank Brennan provide an outline for every one of his witnesses? Does he provide the opposite side every question that he's going to ask? No. No. No.
Being disseminated by this totally independent witness who took no side other than that of the truth.
No, at that point, he was testifying on behalf of the defense. So when they initially did the work for the feds, they were independent. But once they'd got the results, when the results came in and the defense asked them to be witnesses for Karen, they agreed. So at that point, June 22nd, they were not independent. They were planning to testify on behalf of the defense. So that, once again, Hank Brennan, is a nothing burger, in my opinion.
What follows from this outline is then the outline with remarks from this independent expert who knows nobody.
No. The independent expert who knows nobody, no. That has never been stated. Never been stated.
So we see in the margins in the notes, this fair-minded objective witness says,
Fair-minded objective witness. No. At this point, he is planning to testify on behalf of the defense about his results, which turned out to be in favor of Karen Reid.
So not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury. It doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated.
Well, it was dated June 22nd. Unless you're reading something else now. Or unless you're lying again. That was June 22nd. You just said it before.
The TUI request is a recent February response, but they send random documents. There's no real accounting.
Well, they send random documents. There's no real accounting. So they send random documents, meaning the federal government just send random documents, except he said he got that. Half hour later, says he got that from the defense. But no, they just send random documents with no dates on. Except previously, a minute ago, he just said that he's reading from a June 22nd email.
Now, I'm not saying that undermines.
Oh, is someone saying abusive language? Oh, who's saying abusive language? Say it again. The person who said abusive language, say it again. I dare you. Say it again.
the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly
You're not saying they're qualified witnesses.
shows some bias. I've turned over a lot less in this case than this.
Oh, okay. So you turn over, all right, Hank Brennan, you turn over all your conversations that you have, that's your own work product. You turn all that over. You think, oh, that's discoverable. Okay, interesting.
Another comment. Would it be fair to say because you had a lot of nighttime
Oh, you've timed them out. Oh, no.
visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So
It would have been nice to have. You did have that. You did have that. Hank, you had that. Hank, you had that because it was in the report. I'm sure you had that, Hank. All right. Let's listen to, we'll go back to Hank in a minute, but I'm going to play you just the beginning of the video, and I'm going to play a little bit of the trial testimony. So this is a video from June 18th.
So we're going to be able to say the court in case they don't hear the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Very loudly into
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled W-O-L-F-E.
Sir, what do you do for a living?
I am the director of accident reconstruction at a company known as ARCA, A-R-C-C-A.
And tell us a little bit about ARCA. If you can explain to the court what ARCA is and what its primary mission is.
So ARCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
You said you were the current director of accident reconstruction, correct?
That is correct.
Is that a specialty of ARCA specifically?
Yes, sir.
And what sort of contracts does ARCA routinely engage in?
We typically work for law firms, insurance carriers.
What about other clientele? For instance, maybe it's an insurance carrier or a law firm, but what about the ultimate client, the military, Department of Defense? Have you contracted with other entities or agencies, sporting agencies?
Certainly, yes. We've done research for the military. We do player safety for the NHL. So yes, we are involved in a number of research projects as well.
And in terms of ARCA and its commissions and consultation, is it known both nationally and internationally? Is it recognized as a leader in the area of accident reconstruction?
Yes.
As the director of accident reconstruction, do you specialize in not only accident reconstruction, but human factors as well?
Yes, sir.
Can you give me a synopsis of the professional discipline of accident reconstruction? What is accident reconstruction?
Well, I think that's a very broad topic. I look at the cases that come across my desk. I've been involved with pedestrian impacts, and that can be pedestrians getting the side of vehicles, fronts, backs, getting run over by vehicles, being struck by a vehicle, then projected into another vehicle. I've dealt with your simple fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary case to case depending on the facts and circumstances of that case.
And when you say dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects were of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
What about human factors? What does that discipline entail? What is human factors?
Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming onto the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing. And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
All right. So that was a video. Right, so he talks about human factors, nighttime stuff. So pedestrians get run over at nighttime than they do in the daytime. Obviously, there's visibility, there's lights. Your headlights might knock you off or whatever. Strange shadows that you don't think are relevant until you actually hit a person. So it goes into that. All right, so video goes into that. 4 days later, the email that Hank Brennan's reading, because he said it was June 22nd, although he then says there's no date on it, but he said the date, June 22nd. There's a conversation between Alan Jackson and Daniel Wolfe regarding the testimony that Daniel Wolfe is now allowed to give in front of the jury. And one of the things he says is about the nighttime stuff, so they're having a conversation about his testimony. And at this point, he's not independent. At this point, he's been in front of the court on the 18th, 4 days before, and he is now granted the permission to testify on behalf of the defense. So although the report, the experiments that were done were independent of the state's case against Karen Reid, because they were sanctioned, contracted by the federal government the year before, or the months before, once the results were known and the defense were interested in talking to them, there was a communication in March, which was them talking, getting some information. Then they asked them to testify on behalf of the defense. They said yes. Judge Bev wasn't happy about it, but got them in for a voir dire on the 18th of June. Judge Bev gave them the green light. 4 days later, on the 22nd, there's an email between Daniel Wolfe and Alan Jackson regarding the testimony that he is now allowed to give in front of the jury. You see where I'm going with this? There's nothing untoward here. There's nothing untoward here because he's been voir dired. He's been given the green light by Judge Bev to testify on behalf of the defense. He's no longer independent. He's working now on behalf of the defense. He's a witness for the defense. So either Hank Brennan is trying to pull the wool over everyone's eyes, or he's that flaming clueless and he's got himself all confused. Now, I'm prepared to give him the benefit of the doubt, even though in my heart of hearts, I'm thinking that Hank Brennan is a bit of a slime ball and he's done this on purpose. That's what I'm thinking in my heart of hearts. But my head always overrules my heart, and my head is telling me to give him the benefit of the doubt, just for now, even though I'm mad with it.
My specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians.
There you go. That's exactly what he talked about at voir dire. Lighting and stuff, human factors, collisions that happen at night, and he's been given the green light to testify. He's now having a conversation with Alan Jackson, just like any other witness would. Any other witness. Surely this is not something that is a problem. It's not.
Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine.
Well, it is fine. It is fine because now he is a witness for the defense. So he's asking Alan Jackson whether that's good to say, whether that's appropriate to say. Well, it is appropriate to say because the collision that the state are saying happened between Karen Reid's car and John O'Keefe's body happened at night. But the result of their experimentation told them that, in their opinion, John O'Keefe's injuries and his death was not a result of a motor vehicle collision.
Don't tell them.
Shh, don't tell them.
Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
Oh, well, you should have read the transcript. Oh, go and watch day 30. We're going to listen to a little bit of day 30 in a minute. I don't know whether it was cleared up either. I can't remember. However, we can find out ourselves, can't we, in a minute.
And then a bill from ARCA to the defense for $23,925.
So when was this bill? Because he's now leading the court to believe that bill for $23,900 happened last June. But did it? Because he's saying that these documents aren't dated because the federal government just send them random stuff. So is that a bill from Alan Jackson's team, Karen's team, to ARCA? Presumably, because it came from the defence, not the federal government. But what date is that bill? What date is that bill? Because ARCA are no longer contracted by the feds. Their work for the feds is done. So if they want to testify at the next trial coming up in April, they will be just like any other witness, not paid for by the feds, and they will need to be paid. So is that bill for the work coming up for the next trial? That's one thing we need to clarify. If it was a bill from last year, well, what was $23,900 whatever dollars, nearly 24 grand. What was that for? Because the report was paid for by the feds. So 24 grand expenses sounds excessive to me. I don't know what kind of hotels they were staying in. It seems kind of excessive to me. But if this is a bill for the upcoming work, you know, their testimony at the next trial, then I don't see what the problem is. But we do need, I do need clarification on that. I do need clarification on that. $23,995. We need clarification on that, because if that's what they paid them last year, then that should have been disclosed. That should have been disclosed if that happened last year. So I'm reserving judgment on that.
That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any.
Well, yeah, you know all about duping people, because this appears to be what you're doing, whether you mean to or not. I don't know. I don't know.
This, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts.
Yeah. Use ghosts. All right. Judge Bev gets mad. Let's listen to what he says when he comes back.
Right now, it would take me less than a minute. The chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts.
All right. So January 6th, intention to exclude ARCA experts. So they want rid of ARCA. As of January 6th, they want rid of ARCA.
January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts, and that if either party wanted to engage, the original materials are still protected.
All right. So the original materials still protected, but ARCA are no longer working for the feds. Their job's done. Their report's done. So if they want to testify for either side at the next trial, then they're doing so as a private company. That work product is still protected. They can still talk about it, but it's a change. It's a different circumstance than they were at last year.
This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think.
February 13th, the defense. So the defense realizes that now, if they want ARCA to testify at the next trial coming up in April, ARCA are now in a different position than they were in last year. So, maybe these emails that we've engaged in with ARCA, they're now discoverable. We'll send them to the defense. I don't understand. I don't understand what the problem is. because the defense have turned over the stuff that they felt that they should have turned over. They've done it. Because January the 6th, ARCA are no longer contracted with the federal government. So the emails between Daniel Wolf and Alan Jackson are now between a private person and, you know, a potential witness and an attorney. So those emails are discoverable, and he turned them over. Honestly, I don't see what the problem is. But Judge Bev, when she heard that, that should have been her cue to say, hold on a minute. So the defense sent all of that you read before, the defense sent all of that as part of their discovery. Is that right, Hank? But she didn't, because she was mad, and she just called it a day.
I think I said the federal government. It was the defense, February 3rd.
Oh, sorry, I said the federal government. It was the defense. Puts a whole different spin on it, doesn't it? Yeah.
13th, 2025, they sent us the emails and the direct examination outline.
Oh, February 13th, they sent us the emails and the direct examination outline. Oh, very different than saying that they were hiding everything and it was the federal government that turned all this over. Unbelievable.
We reached out to the federal government again because I was curious about the change in position on February.
You were curious about the change in position. The change in position is simple. The change in position is ARCA's work for the feds is done. They're no longer contracted by them. That's the change in position. Okay, now, if they want to testify, they do so as a private person.
6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from
retaining. I don't know what you're talking about.
Them. So we've refrained.
Oh, we've refrained as a favor to the defense. We've not contacted ARCA. Because the defense might want to, because we're being so kind.
We will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave.
All right, and then she goes into, is next week okay for everybody? Doesn't say, oh, okay, so that was actually all defense. The defense sent all of that. Well, that puts a little bit of a different spin on it. Mr. Jackson, would you like to comment? No. What she's allowed is a direct ambush by Hank Brennan towards Alan Jackson and done absolutely nothing, absolutely zero, zilch, nada, to try to find out why Hank Brennan said that all that came from the federal government. And then half an hour later, he walked it all back and said all that was from the defense. The defense did turn over those emails as part of the discovery. So what's the big deal? Where's the problem? There's no problem here. Unbelievable. Anyhow, just for shits and giggles, let's just play a little bit of this. This is the testimony of Daniel Wolf. The real reason I want to play this is because Judge Bev really fancies Daniel Wolf. You can, if I can get it right, I'll show you. If I can stop it at just the right second, I'll show you. So this is Daniel Wolf testimony, day 30. It's June 24th, 2024. Just for shits and giggles. To have a laugh at the Judge Bev. It is very one-sided. It's incredibly one-sided. Like she said, absolutely zero about the Commonwealth presenting a video that was fake. It was inverted. No sanctions, nothing. Even though the jury was completely misled by it. But no, nothing. And then when David Inetti tried to question her on it, she completely shut him down. Not surprised he was mad. She just completely shut him down. Unbelievable. Unbelievable. Watch her in a minute. Watch her.
I'll step right in and just watch the step on me. Stay in the face.
This will crack me up to my dying day. And he comes in, she like does this like side eye. She like looks him up and down. Look at her.
You saw the evidence given to the court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth. So
And she's trying to play it cool. Look at her. She's trying to play it cool, swinging in her chair. She's like a little teenage girl.
Yes.
She's still watching it. She's still watching.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolfe, last name spelled W-O-L-F-E.
I mean, a lot of people think he's easy on the eye. He's not my type personally, but, you know, I could see why Judge Bev might be interested in him anyway. Anyway, he comes, he gives really good testimony for Alan Jackson. Adam Lally he makes him, Adam Lally, the prosecutor, makes himself feel really small during the cross-examination. This guy knows his stuff. The next guy who comes along, it's worth a watch. If you didn't watch the first trial, this testimony is definitely worth a watch. It's very eye-opening. And then the cross-examination is hilarious. And then the next guy that comes up is also Arca, I think. This is the next guy that comes up. So the link to this is in the description. I only wanted to play that because of Judge Bev. But anyhow, there we go. So, yeah, we wait. We've got to wait a week now. We've got to wait a week now and see whether Judge Bev has realised that this is a storm in a teacup, whether she's going to discipline Hank Brennan for his faux pas, or whether there is actually something in this that we're not aware of, and there were shenanigans, you know, potentially, if nearly 24 grand was paid to Arca whilst they were under contract with the federal government, that should have been disclosed. It should have been disclosed. But let's wait and see. Because the defence were not allowed. They weren't given the opportunity. She shut the hearing down. That was that. They weren't given the opportunity to come back and explain themselves. As I said before, maybe Judge Bev thought that was the kindest thing to do. Just to shut it down and do an investigation and come back next week and, you know, clear it all up. But when Hank Brennan came back and said that those emails were not from the federal government. They were sent to the prosecutor's office by the defense. It puts a whole different spin on it. It makes it seem very different, much more like Hank Brennan is trying to just find something, anything, to get these Arca witnesses excluded because they are very impressive. I don't know. We got to wait. We've got to wait a week. So it's the 25th, I think. Hold on. They talk about scheduling here because Alan Jackson has an issue on it. I can't remember what the upshot was, but we've got it right here. We can just listen.
Before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock, a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Here, if I may hand up the discovery. that's
Thank you.
provided by the defendant reference side.
Oh, great, thank you.
Is there any way she needs to smoke for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
That's what I heard in cat.
Thank you.
Your Honor, we'll accommodate the 25th. One way or the other.
All right. So we'll see everyone.
I'm sorry.
25th. All right. We've not got a time, but presumably 11 a.m., presumably the original time. So we wait until then. It's going to be a very, very interesting hearing. I'd like to be a fly on the wall to hear what happens in the back rooms of these places in the next week. And the Judge Bev's blood pressure's come down, and once she realizes that, oh, the defense sent all this, that puts a different spin on it. Maybe once she calms down, she'll realize that it's maybe not as bad as she thought. Although that 24K bill, I want that explaining. I do. All right, guys. So that's all I've got for you. I thought I'd bring you a little bit of Karen Reid action. And yeah, it's interesting. If you don't know very much about the case, then there's an entire trial that lasted 2 months that you can dig into. You know, you can dig into that at your leisure if you would like. And the retrial is due to start in April. If she kicks the defense off, which I don't think she will, but that's going to delay matters. But I don't think she can kick them off. But we'll see. We'll see. All right. Thank you all for joining me. I've not had any donations. 5 memberships gifted by Kimberly. I thanked you for that, didn't I? So, all right. Welcome to all the new members. Thanks as always to the mods. And enjoy the rest of your day. I shall speak to you tomorrow. I don't know what case I want to do tomorrow. I'm completely avoiding the Sebastian Rogers case at the moment, because that is a mess that, well, it's just a mess. It's just a complete mess. A complete mess. But I don't know whether I'm going to do Delphi again or a different case entirely. I'll decide. But until then, I shall see you soon. Bye, folks.